Hey everyone, it is RobbRyder, and guess what? They volunteered. They volunteered to be governed by administrative law. And an example of this is if you've been in the military, you know that once you join the military, all of a sudden you're governed by this code called the UCMJ, Uniform Code of Military Justice. And so they don't use civilian law against you, they use the UCMJ, and it starts with as simple as somebody putting a complaint in to the county clerk, and it could end up as an Article 15, an administrative non-judicial hearing, basically, or it could go to a court-martial. And so, you could get shot for not following what the UCMJ says. That's pretty powerful administrative law. And it doesn't apply to everybody, it just applies to those that consented to the jurisdiction. And as it turns out, I believe anybody who has a license of any kind, whether it's a business, a artificial person, or a natural person, whose artificial person has the license, it's all by license, right? And that's part of commerce. And because they got the license, they volunteered to the jurisdiction. So let's go look and see what maybe. Man, that never frickin' fails. Sorry about that. Let's go and see what there may be for us on the administrative side. I know some people want to keep using the courts, and that's okay with me. If the answer is to keep going back and hoping you get a dismissal, then by all means do it. But I'm not looking for that answer. I'm looking for a remedy, and I want my property back. And so these are some excerpts out of a bunch of stuff we're going to look at today. You're going to read what came off the FTC site, Federal Trade Commission site, that is. Look at the Federal Trade Commission site. Look at how easy it is to put a complaint into the Federal Trade Commission. And, that would cover that part. And then what I'm going to do is I put together a whole bunch of different PDFs of different things that I've looked at in the last couple of years, especially, from foreclosures to traffic tickets to, these kind of things, to point out, well, this would be something that would be covered by the FTC, Federal Trade Commission, in its jurisdiction. And it could be from the government, or it could be from an attorney trying to take your property, or whatever, because they all have licenses. So let's read on. So in 1914, Congress passed two additional antitrust laws. The Federal Trade Commission Act, which created the FTC, and the Clayton Act. So the Federal Trade Commission Act, the act that created the Federal Trade Commission, is in itself considered an antitrust law. And there was already one other one, the Sherman Act. So the Sherman Act outlaws every contract, combination, or conspiracy in restraint of trade, and any monopolization, attempted monopolization, or conspiracy of combination to monopolize. Conspiracy or combination to monopolize. And as you see, we'll be talking about these things called coercive monopolies, and they're just described to me, well, that's the government, right? The corporate state is a coercive monopoly. And because they took, when you look at what the names of some things are, it'll say it's a body corporate and a body politic. Well, that's two different entities joined together. That's a combination. And that combination may not be for your benefit because it makes a coercive monopoly. That's not only the government, but it's a business entity looking out for its own concerns, governed by the same people. Right? So my point is, the government, what you think of as the government, which really isn't, because they don't have a proper oath or bond at the local level, all the way up to so far the House of Representatives. The U.S. House of Representatives, they do not have a sworn, subscribed oath of office filed for record as required by 2 U.S.C. 25. I believe that's what it is. 2 U.S.C. 25, United States Code. If you just read what that says and go ask your congressman if he's, to produce this subscribed copy, And they're going to tell you, well, we took one at the beginning. We all stood up and took an oath. Yeah, but that isn't what the law says. So, you know, so then what are they if they're not actually in the office? Who are these people? Well, they work for a corporation that's usurped the powers of the government. And more on that later. But okay. So, although most enforcement actions are civil, the Sherman Act is also a criminal law, and individuals and businesses that violate it may be prosecuted by the Department of Justice. So, if you make a monopoly, well, that could be criminal, and you could go to prison. The Supreme Court has said that all violations of the Sherman Act also violate the FTC Act. And this is where it gets good, because now only the FTC brings cases under the FTC Act. Well, now this is me speaking. So that would make the FTC the public's prosecutor. The attorneys general, your solicitor general, in a civil matter of which you are merely an ex-rel plaintiff, a party of interest in a matter touching on both public and private wrongs. And the FTC is going to sue it. And you're just ex-rel because you brought it to their attention. You have a private wrong done to you because a public wrong has been done by somebody else. And so they will get you your compensation and prosecute the offender for the violation. And they consent because they got a license. Okay, it's Sunday, May 31st, 2015. And my email is RobbRyder, is courtofrecord at AOL.com. I apologize. I know a lot of people email me, and I may not email you back on what you sent me because it's not what I'm looking at right now. And sorry, man. God's got it down to a fine. For myself, I'm at a point, and I'm not looking to explain things I might have said 2 years ago or help you claim your name or any of this other stuff, right? That was then. This is now. I'm in the now, and now is getting the FTC to prosecute these people for antitrust activity or debt collection. So until we get all that figured out, if you could, please donate, because it is the 31st and I can't pay my rent. Can't pay my cable bill. Damn. Happened again. You could do it by PayPal, which is my daughter's email address is the PayPal account name. Or you could slip it in the mail, like Danny from Texas did. Put it in an envelope, some little aluminum foil. Next thing you know, right? It just doesn't happen quite enough. Thank you very much for those that do it, but it just wasn't. Everything I do is on donation. So enough said, and we'll move on from there. Now, why is this important, right? Why maybe administrative law? Well, because, on April 8th of 2015, Governor Bruce Rayner, Illinois, who's been barnstorming the state to promote his message that Illinois' government is corrupt and in need of structural reform, took aim Tuesday at the Illinois Supreme Court, saying he doesn't trust its justices. The Republican governor has often criticized the state system of electing judges to a branch that has advocate barring trial lawyers for making campaign contributions to them. Has an advocate barring trial, whatever. The governor's remarks Tuesday in a suburban newspaper editorial board took the argument a step further, targeting the high court specifically. I don't trust the Supreme Court to be rational in their decisions, the governor said. Rauner told the Daily Herald, I think they're just activist judges who want to be legislators. Asked by the newspaper if he believes the state's high court is part of a corrupt system, he said, yes. We have a system where we elect our judges, and the trial lawyers who argue cases in front of these judges give campaign cash to those judges. It's a corrupt system. Now, I just said here, judges on the bench and has advocated barring trial lawyers from... Oh, he's barring them making contributions. Okay. Apparently they can. But I think what he's saying is if you were to go look at the campaign contributions to these judges, you could probably make a case that corruption that way. My point is he's saying that the courts are corrupt. Period. He's just giving you a reason. He's saying the courts are corrupt. And I have a really good reason myself for believing why he says these things, and it's because of the stuff we sent in to all the different agencies in Illinois about Roe's case, about the fact that the attorneys were not using the name that's on their license, not as it appears in as they registered it on the ARDC, the Attorney Registration Disciplinary Committee website. That's the way they have it there, but when you go and look at it on the paperwork they do, they don't use their middle name, they use a middle initial. So they're not using the name that they've certified to be the name that they're going to do business under as an attorney. So they're not doing it as an attorney, and, well, we were trying to point that out, but that system just doesn't seem to care, because it's a system made up of all those people doing the same thing. Nobody ever shows up in their official capacity. I don't believe the governor shows up in his official capacity, but hey, at least he said the truth. Okay, so let's go from there. Okay, so what we got? Like I said, we're just going to read some things that come out of different. This here comes right off the FTC website. It's just easier for me to read it if I put it on a Word document. So, guide to antitrust laws. Free and open markets are a foundation of a vibrant economy. Aggressive competition among sellers in an open marketplace gives consumers, both individuals and businesses, the benefits of lower prices. You get the idea. The FTC competition mission is to enforce the rules of competition marketplace, the antitrust laws. What's the FTC's competition mission? To enforce the rules. And when they say that, they mean the antitrust laws. Well, and one of those, besides the Sherman Act, is the FTC itself. The act that made the FTC is a frickin' antitrust law. The FTC's Bureau of Competition, working in tandem with the Bureau of Economics, enforces. Who enforces? Well, the FTC's Bureau of Competition and the Bureau of Economics enforces the antitrust laws for the benefit of consumers. And we'll see that a consumer is anybody who's either alleged or owes a debt. That's what a consumer is. You're either alleged to owe a debt or you do owe a debt. So everybody's a consumer because somebody's going to say you owe them a debt. And that's why you're in court in the first place. Right? It's a false accusation that you owe somebody a debt. Bureau of Competition, blah, blah, blah. I'm not going to read all this, but so anyways, this is where Congress passed two antitrust laws, the Federal Trade Commission Act, which created the FTC, and the Clayton Act. The antitrust laws prescribe unlawful mergers and business practices in general terms, leaving courts to decide which ones are illegal based on the facts of each case. Right? The facts of the case. The court have applied the antitrust laws to changing markets from a time of horse and buggies to the present time. Yet, over 100 years, antitrust laws have the same basic objective: to protect the process of competition for the benefit of consumers. Keeping prices down, quality up, well, that doesn't seem to be working well, and it's because we're not pointing out the fact that these people are committing antitrust violations against us to the FTC, which is the only agency that has the jurisdiction to prosecute a case under the Federal Trade Commission. They'll investigate it, in other words, right? They're going to go look at the facts. That's what it says. I'm not going to say they're doing it. I just do everything based on what it says. And I go find out by doing it. The Sherman Act allows every contract, combination, or conspiracy and and any monopolization, attempted monopolization, or conspiracy or combination to monopolize, those are all outlawed under the Sherman Act. Long ago, the Supreme Court decided the Sherman Act does not prohibit every restraint of trade, only those that are unreasonable. Although most enforcement actions are civil, the Sherman Act is also a criminal law, and individual businesses that violate it may be prosecuted by the Department of Justice. So you get a civil. What'll happen then is the FTC will go do the civil case and get all the evidence set up, and then they'll hand it over to the U.S. attorney and say, here, we won the civil one. I think you have everything you need here to get your criminal conviction. Criminal prosecutions are typically limited to international clear violations such as competitor fixes and rig pricing. How about when a cop pulls you over with false flashers and flags on the highway, which is part of interstate commerce? That's like crossing the state line, kidnapping type stuff. Now the federal government's involved. And, coerces you into giving him a unilateral contract that you're going to agree to whatever he just said. And basically, going to try to get money from you. Well, that's taking money from you with no compensation. That's antitrust. That's that coercive monopoly exercising its supposed jurisdiction. Under federal law, the maximum fine may be increased to twice the amount the conspirators gained from the illegal acts or twice the money lost by the victims of the crime, if either of those amounts is over $100 million. What? Jeepers. We're talking big money. $100 million, $1 million, 10 years in prison. Right? Well, these are the civil fines, and if the victims, right? Now we're talking about the victims. You're the victim who brought it to their attention. Twice the money lost by the victims. Right? So do you want to prosecute it yourself, or do you want to have the Federal Trade Commission prosecute it? You can go take it to court by yourself and try to do it that way, and pay to have it done. You can go pay to do it yourself, or you could give it to them because it's free to give them a complaint, and you just ride the rail as the Ex-rel plaintiff and let them do all the work. Let them be your Solicitor General. The Federal Trade Commission Act bans unfair trade methods, unfair methods of competition, and unfair or deceptive acts or practices. Okay. You can't lie, cheat, and steal. The Supreme Court has said that all violations of the Sherman Act are also violate the FTC Act. So if it's a monopoly, well, that's the Sherman Act, but it also violates the FTC, so take it to the FTC and let them prosecute it as they wished. You can just tell them it's a coercive monopoly and give them some evidence. Give them probable cause to do the investigation. Thus, although the FTC does not technically enforce the Sherman Act, it can bring cases under the FTC Act against the same kinds of activities that violate the Sherman Act. The FTC also reaches other practices that harm competition, right? Practices. Somebody's practicing law, somebody's practicing, has a doctor's practice. All these different kinds of practices. They all have licenses. They're all going to end up coming through this through the FTC, the Federal Trade Commission. Clayton Act also authorizes private parties to sue for triple damages when they have been harmed by conduct that violates the Sherman or Clayton Act, and to obtain court order prohibiting the anti-competitive practice in the future. And so again, you can do all this, or you can let the FTC do it. And if they find criminal activity, well, they'll give it to the DOJ, and they can go prosecute for the criminal activity and still get you your civil remedy and civil remedy. Yeah, excuse me. The enforcers, both the FTC and the U.S. Department of Justice Antitrust Division, enforce the federal antitrust laws. For example, the FTC devotes most of its resources to certain segments of the economy, including those where consumer spending is high, such as healthcare, pharmaceuticals, professional services, need I say more, food, energy, that'd be electrical utility, certain high-tech industries like computer technology and internet service. Oh, they consider the cables to be an instrumentality of interstate commerce. The pipelines, all these things, anything that goes through a pipe or a line through your neighborhood is under the jurisdiction of the FTC. Go figure. Before opening an investigation, the agencies consult with one another to avoid duplicating the efforts. Oh, you already got most of it done? Well, hand it on over. Pre-merger notification filings, correspondence for consumer or business congressional inquiries, yada, yada, yada. See, these pre-merger notification filings, well, to me, that's like this idea of you could be a body corporate, or you could be a body politic, or you could be both. Well, that's a merger. Was there a notification that we're going to merge these two together? So how does this work? Well, let's take a look. The FTC's administrative complaints initiate a formal proceeding that is much like a federal court trial, but before an administrative law judge. Why? Because the people that's going to be against volunteered to the jurisdiction. The FTC's administrative complaints initiate a formal proceeding. You get the complaint in, there's going to be a proceeding. That is much like a federal court trial. Evidence is submitted, testimony is heard, witnesses are examined, cross-examined. If a law violation is found, a cease and desist order may be issued. Initial decision by an administrative law judge may be appealed to the Commission. Final decisions issued by the Commission may be appealed to the U.S. Court of Appeals, ultimately to the Supreme Court. Well, is that to ensure due process? Because who gets to appeal to the, that's what the district courts do. You lose in district court, you take it to the U.S. Court of Appeals. Then you could take it to the Supreme Court. You're doing the same thing here. I believe this commission to be much, much, much like what we believe to be a district court is. If the commission's position is upheld, the FTC, in certain circumstances, may even seek consumer redress in court. So, yeah, if it's upheld, now they're going to go and seek consumer redress in court. You really want to have us go to court to get it, or you just want to, keep it a civil matter and pay the fine? The 3 times. If the company violates the FTC order, the commission may seek civil penalties or an injunction. So if the company violates an FTC order, and we're going to see one of these FTC orders in a part of the act we're going to read, then they can seek civil penalties or an injunction. They can make them stop trying to collect a debt. That's what we're going to be looking at. Because all these people we're dealing with are acting as debt collectors. That's their company. And you're a consumer, somebody who's alleged or does owe a debt, and they're a debt collector who collects debts that are assumed or actual. And if your body happens to be the collateral, well, they'll collect that too. In some circumstances, the FTC can go directly to federal court to obtain an injunction, civil penalties, or consumer redress. Come on. You don't get better than that. States, attorneys, private parties, issues in international jurisdiction. That's enough of that. Okay, that's good. But that is good. It was number 2. What do we got for number 3? The FTC is an independent agency of the United States government, established 1914 by the Federal Trade Commission Act. Its principal mission is promotion of consumer protection and the elimination and prevention of anti-competitive business practices such as a coercive monopoly. And that's what a usurper of a government office is doing. He wants to use the coercive powers of government to get you to comply to his taking your property. Or to at least to keep them offices empty so there's nobody for you to go to say, hey, this dude's just taking my property. You can't go local, then people don't have an oath. Don't have an oath, don't have a bond. They're not holding the office. They're not using the name on their license. I'm talking about everybody from the lawyers, doctors, psychologists, counselors. Who's what I'm trying to remember, though? Oh, CPAs, certified public accountants, who are supposed to be the ones doing the audits on like a CAFR account. And when you go look, you'll see these people don't have an oath, or they don't have a license. Right? So now an audit that was done in something that has to do with public money hasn't been done properly. So now I tried to take that to the government accounting office, but they didn't want to pay much attention to it. And that's one of the things I'm going to be pointing out when we get to the things to point out. But Anyways, I'm going to take the Federal Trade Commission and say that the county that you see, that you think is there, is actually a coercive monopoly that's usurping the powers of the government. Okay, so the Federal Trade Commission shall be authorized to enforce compliance with this subchapter. So what do we read? Oh, okay, so now I'm actually reading this. This comes out of the Act, right? Maybe we'll just go to this Act. So part of the FTC, that made the FTC, is the Fair Debt Collections Practices Act, in which it says, as a public service, the staff of the Federal Trade Commission has prepared the following complete text of the Fair Debt Collection Practices Act, 15 U.S.C., some part of the Act. Please note that the format of this text differs in minor ways from the U.S. Code, the West U.S. Code annotated. For example, this version uses FPCPA section numbers in the headings, yada, yada, yada. So you got to be careful how you quote it. Excuse me. Or how you cite things. So the easiest way to do it is just cite it the way it says. This title may be cited as the Fair Debt Collection Practices Act. That's all you need to tell them, is that you are referencing the Fair Debt Collection Practices Act. Probably with the quote marks. But why did Congress do this? Well, what did they say? Congressional findings and declaration of purpose. There is abundant evidence of the use of abusive, deceptive, unfair debt collection practices by many debt collectors. Abusive debt collection practices contribute to the number of personal bankruptcies, marital instability, loss of jobs, and to invasion of individual property. I would say you're absolutely correct. Inadequacy of laws. Existing laws and procedures for redressing these injuries are inadequate to protect consumers. It's why the best you can ever be in court's a fucking defendant. Well, excuse me. I mean, you usually are. Forgive the F word, but they happen to come out. Right? Normally, you're the defendant. Interstate commerce. Abusive debt collection practices are carried on to a substantial extent in interstate commerce and through means of instrumentalities of such commerce. Even where abusive debt collection practices are purely interstate in character, they nevertheless directly affect interstate commerce. Why is that important? Well, I just put it in federal jurisdiction. Cross state lines. Purposes. It is the purpose of this title to eliminate abusive debt collection practices by debt collectors. Let's go ahead and use it. All right, so this is what they wrote for us. Now, you can argue, it's just administrative law, but it's the law that the people you want to go against have agreed to be bound by. It's their law. The term bureau means the Bureau of Consumer Financial Protection. The term communication means conveying information regarding debt directly and indirectly. I don't need that. The term consumer means any natural person obligated or allegedly obligated to pay a debt. Made everybody a consumer. The creditor means the person who offers or extends credit, creating a debt, or whom a debt is owed, but such term does not include any person to the extent that he receives an assignment or transfer of the debt, in default solely for purposes of facilitating collection of such debt for another. So in a foreclosure, they're always assigning the debt to somebody else. That didn't make them the creditor. Why is that important? Because it don't matter who they gave it to. The only person that can be the plaintiff is the creditor. He needs to bring the charge. And the one it was assigned to is not the creditor. That means the plaintiff in a foreclosure case, which we already knew, is a fictitious entity. And this is a simulated legal process. And as you're going to see, well, those kind of things might be against this law, and therefore you would bring a claim, or you would put a complaint in against the attorney of record for bringing this into, for getting you involved in this. He's the one who's sending you the paper. More on that stuff later, but I'm just saying that's really how it works, right? That's how you get a foreclosure out of the court of judges who don't have an oath, don't have a bond, are not going to let you win in their court. The best they're ever going to let you do is have a dismissal. And they could drag it on for a couple, 2, 3 years. Okay, dismissed, and then boom, they get you for something else, and you're back in there again, and yeah, okay. Not for me. No, I'm going to go and say, hey, you're a false accuser. Who do I see to get you to never do this again? It looks to me like it's the FTC. The term debt means any obligation or alleged obligation. Don't even need to owe it. Just, that's what a debt is. You either do or you're alleged to. Of a consumer. Who's a consumer? Anybody who's alleged to owe a debt or does owe a debt. Arising out of a transaction, for which money, property, insurance, or services which are subject to the transaction are principally for personal, family, household purposes. A debt collector means any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the collection of any debt, or who regularly collects or attempts to collect, directly or indirectly, debts owed or due or asserted to be owed or due another. That's your frickin' utility company. Every month they send you a bill. Send you a bill. Send you a bill. Send you a bill. They're just a debt collector. Collecting a debt. Regularly. Who regularly collects or attempts to collect, directly or indirectly, debts owed or due or asserted to be owed or due. You don't even need to owe it. Just assert it. Here, pay. And so as I pointed out in my last video, in my case, Consumers Energy Company is the one I have my service with, apparently. They're the one who sends me the bill. In Michigan, thankfully, or I wouldn't even be onto this stuff, it says in the Constitution of the state of Michigan, 1963, Article 7, Local Government, subsection 29, wherein every public utility or public utilities have to have a franchise with the township. Right? They have to have a license with the township. And by gosh, I went and looked at my township's ordinances, and they have a place for an electrical franchise, but it's not Consumers Energy. It's some Great Lakes Energy cooperative. Okay, so then why am I paying Consumers Energy if they don't have a franchise in my township? That's a damn good question. Because the more I look at it and think about it, well, what's happened is if I owe anybody, it would be Great Lakes. But what Consumers did is they broke the law, and they came and put a meter in Great Lakes line. Great Lakes has a Great Lakes Energy Cooperative has a franchise for the wire, the transformers, that kind of stuff. Right? So if you cut into their wire, well, then you just broke the law. And I didn't do it. Consumers Energy did. They put their meter in somebody else's wire. But it gets even better because this cooperative, although it has an electrical franchise, doesn't have a franchise to sell you any power, just to transmit it. So technically, what I believe will end up happening is you will have because they do have a franchise. This Great Lakes Energy Cooperative does have a franchise. That I will be their customer, and I'll have to pay the delivery fee for the electricity, but not the energy fee for the energy, because energy should be free. Or if not free, at least as part of the public trust, and I've already paid for it. I have one share of the public trust, so I get electricity. So anyways, so that makes them a debt collector. Get the picture. Foreclosure, debt collector. They take you away with a warrant. That's a debt collector. It's just in that case, the body was the frickin' collateral. So notwithstanding the exclusion provided by Clause F of the last sentence of this paragraph, the terms includes any creditor who, in the process of collecting his own debt, uses any name other than his own, which would indicate that a third person is collecting or attempting to collect the debt. So the creditor goes to being a debt collector as soon as he uses any name other than his proper person name. For the purpose of Section 808, which term also includes any person who uses any instrumentality of interstate commerce or the mails in any business, the principal purpose of which is the enforcement of security interest. And then it goes on to say what it doesn't apply to. But this last one, right? Any person who uses any instrumentality of interstate commerce, well, again, that's the highways or the mails, in any business, the principal purpose of which is the enforcement of a security interest. Just as soon as they send you that paperwork for your foreclosure, right, it's about the security interest. Who gets interest in the security? It's your security. You're supposed to give them security until the mortgage is satisfied. And then the security should return to you. But they're going to say, no, they have the security interest, and that's what they're going to try to enforce in the court. So my point is, just as soon as that paperwork came and said, hey, you're in a foreclosure, hey, guess what? You're involved in antitrust or you're a debt collector. That's really all it means. You're a debt collector. Now, debt collectors have to follow this particular section of this act. Any officer or employee of the United States or any state, to the extent that collecting or attempting to collect any debt is in performance of his official duties. Excellent. I'm all for that. Just prove to me that you're an officer. Where's your oath? Where's your bond? All right? Because if you ain't got an official bond, you don't have no official duties. And they can say, yeah, we can be self-insured. Well, yeah, I'm going to let the FTC decide. Now, this blew me away. The term state means any state, territory, or possession of the United States, the District of Columbia, the Commonwealth of Puerto Rico, or any political subdivision of any of the foregoing. So my little township is considered a state by this act. I don't know how that's all going to play in. It blows me away. All right, you want a new definition of a state? It's your township. Which it should be. It's a self-governing territory. That's all a state is a defined territory that's self-governing. So you're a state. Acquisition and location information, identify himself. I don't know that I needed to cover that so much. This is how they're going to get the information. Forgetting all that, right? You guys get your information how you're going to. We'll get to the parts that we need to know. So, what can't they do? A debt collector may not use any false, deceptive, misleading representation or meaning in connection with the collection of any debt without limiting the general application of the foregoing. The following conduct is a violation of the section. So we're not going to limit it to what we're about to say. This is just to give you an idea of what we're talking about. Please pay attention to the word false. The false representation or implication that the debt collector is vouched for, bonded, or affiliated with the United States or any state, including the use of any badge, uniform, or facsimile thereof. Brother, you had better be a peace officer. Yeah. See, so they're saying there's debt collectors that wear uniforms and have badges. They do exist. Or they can't be a debt collector and be bonded or affiliated with the United States or a state, including the use of any badge, uniform. They can't do that ever. I don't know, but when they take you away for a warrant because you failed to appear, it's because that failure to appear means you owe on a bond now. And we'll look at some of the ways they get you to sign a bond. The false presentation of the character or amount or legal status of any debt. Right? They act like this, that you really do owe this debt. Yeah, you owe it to me. Sure. It's legal. Well, that's incorrect. It's a falsehood. The false representation or implication that any individual is an attorney or that any communication is from an attorney. Again, if the attorney isn't using the name that's on his license, or as you would find it on the State Bar website, or whatever the official list of attorneys are in your state, here in Michigan, it's the State Bar of Michigan. And if you go and look on that site, And the way you see their name being used there, if that isn't the way they wrote it on the piece of paper, they didn't do it as an attorney under their license. So it's a false representation that he's an attorney. That's the attorney's got the middle name and not the guy with the middle initial. The representation or implication that non-payment of any debt will result in arrest, imprisonment of any person, or seizure, garnishment, attachment. Well, jeepers, Ro, I think they took you to jail because they said you didn't appear and that you owed a bond. Basically for not paying your bond. Of course, that isn't what they say, but that's why they come and get you. The threat to take any action that cannot be legally taken or that is not intended to be taken. And so this is why in all these courts you go into, they don't have any court seals. It's all under clerk seal. You're not actually in court. These are not courts of record. All right? They're courts of intimidation. Private courts with private prisons to coerce your agreement to their terms. I think that's antitrust. The false representation that a sale, referral, or transfer of any interest in a debt shall cause a consumer to lose any claim or defense to payment of the debt and become subject to any practice prohibited by this title. Right. So just because they transferred the debt, like they do with mortgages, doesn't give anybody a right to bring a claim against you because they are not the creditor. The false representation or implication that the consumer committed any crime or other conduct in order to disgrace the consumer. Communicating or threatening to communicate to any person credit information which is known or should be known to be false, including failure to communicate that a disputed debt is disputed. Right? So messing with your credit score. These are all the things that a debt collector cannot do. The use or distribution of any written communication which simulates or is falsely represented to be a document authorized, issued, approved by any court, official, agency in the United States, or any state, or which creates false impression as to source, authorization, or approval. And that's every freaking court case you're in. They're all simulated legal processes. I can't say it is if you actually harm somebody. I don't know how that is. I just know that the things I'm talking about with debt collectors, they're all simulated legal processes. You're not in court. Go ahead and stand there and bellow all you want. All right, get a dismissal. Or do you want to get 3 times your damages back? And that may make them stop from doing it anymore. Oh, shit. They hit back. Well, they got the FTC on their side. The use of any false representation or deceptive means to collect or attempt to collect any debt or to obtain information. Right? If you lied, cheat, or steal, it's against this act. Well, this is, this is defining a crime as a sin because it's a false representation. It's a falsehood, and that's what all sins are. That's what that type of sin is. A falsehood is a sin. It's called a lie. The failure to disclose an initial written communication with the consumer, initial communication with the consumer is oral, and that initial oral communication that the debt collector is attempting to collect, blah, 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 blah. The false representation or that accounts have been turned over to innocent purchasers for value. The false representation that documents our legal process. That is the initial piece of paper they send you for that court case. Because the name of the plaintiff, the dude in the plaintiff box, is a fictitious entity. He does not exist. And it's contempt of court to sue in the name of a fictitious entity. But the whole paperwork is, there's just all sorts of errors on them. And we'll go look at some more. I've done that stuff. So I spent the last year and a half showing, a couple of years, boom, 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 boom. So you just have to take my word for it or go, dig deeper yourself, but it's enough for me. Okay, well, those are the falsehoods. Now we got unfair practices. A debt collector may not use unfair or unconscionable means to collect or attempt to collect any debt. The collection of any amount, including any interest, fee, charge, or expense, incidental to the principal obligation, unless such amount is expressly authorized by the agreement created. Yeah. So they can't get you for the attorney fees and all the other crap that they try to get you with. The acceptance by a debt collector from any person of a check or other payment instrument post-dated more than 5 days unless such person is notified. Yeah, I didn't get too much on that. But. Okay, so now we're getting into what we need to do. Be proactive. You're going to make them validate the debt. And I mean this, do this with your utility company. Make them validate the debt. And this is why. Within 5 days after the initial communication with consumer in connection with the collection of any debt, so that's within 5 days of you getting the frickin' bill, a debt collector shall, unless the following information is contained in the initial communication or the consumer has paid the debt, send the consumer a written notice containing the amount of the debt, the name of the creditor, that's actually who it's owed to, not who's trying to collect it, a statement that unless the consumer within 30 days after receipt of the notice disputes the validity of the debt or any portion thereof, the debt will be assumed to be valid by the debt collector. A statement that if the consumer notifies the debt collector in writing within 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of the judgment against the consumer. So you just need to tell them that you dispute the claim, that you dispute the debt, and you want them to get a verification of the debt or a copy of the judgment in accordance with the provisions of whatever the name of this act was, subsection 809, validation of debt. You could just copy and paste this whole part and put it in and say, here, send me something make sure that whatever you send me complies with all sections of this 809. A statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor if different from the current creditor. But disputed debts. If the consumer notifies the debt collector within the 30-day period described in Section A, so within 30 days you get in the bill, that the debt or any portion thereof is disputed, or that the consumer request, just because you care and you want it, or that you just request the name and address of the original creditor, the debt collector shall cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or any copy of the judgment. And so if you did this with this is why, like your credit card bill or utility bill, these are all prime examples of what to use this for. So you're going to send it and ask them to verify the debt per this act. And if you do it within 30 days, they have to quit trying to collect on it until they have. But if they do, well, that's when you're going to get that notice, say you're past due. And as soon as they say you're past due, well, they just broke the law because you contacted them, verify the debt, give me the names, show me the paper. They don't do that, and they send you a past due notice. Well, they're in violation of the act, right? And now you have your evidence. And a copy of such verification or judgment, the name or address, original creditor, is mailed to the consumer by the debt collector. So quit calling them the utility or the bank, because it's not the bank. The credit card's not with the bank anyways. That's, again, it may be a company, but it's not the bank, right? It's a separate company of some kind, collection company. Trying to collect the bank's debt is what they're saying. Well, then show me the original debt with the bank. Just show me the debt. Verify it. The failure of a consumer to dispute the validity of a debt under this section may not be construed, may not be construed by any court as an admission of liability by the consumer. You just haven't complained yet. I better go back up here. Unless the consumer has notified the debt collector in writing that the debt or any portion of the debt is disputed, or that the consumer requests the name and address of the original creditor, any collection activities. That's what happens when you start in the middle of a sentence, Bob. Collection activities and communications that do not otherwise violate this title may continue during the 30-day period referred to in subsection A, unless the consumer has notified the debt collector in writing that the debt or portion of the debt is disputed, or that any consumer request the name and address of the original creditor, any collection activities and communications during the 30-day period may not overshadow or be inconsistent with the disclosure of the consumer's rights to dispute. No matter what they do, right, if you put it in within 30 days, they got to get you an answer. Before they can come and try to collect the debt again, they have to have given you this information. The failure of a consumer to dispute validity, we did that one. Legal proceedings. A communication in a form of a formal pleading in a civil action shall not be treated as the initial communications for the purposes of this subsection. All right, they can't wait till they get you into court and then give you the frickin' what's needed to satisfy this act, which is because they're supposed to do this anyways. Within 5 days, right? They're supposed to have sent you. What is the amount of the debt? Who's the name of the creditor? They're supposed to send this to you. 1, 2, 3, 4. Statement. 5. Right? If they haven't done it, and they haven't, well, they can't wait till they get to court and put it in to satisfy this act, which is probably what would try to do. If they're actually in court, maybe. I don't know. But what I know is it says they can't do it. The sending or delivery of any form or notice which does not relate to the collection of any debt is expressly required by the Internal Revenue Code, title something or other, and any provision. I'm running out of steam on this. Little legal actions. In the case of an action to enforce an interest in real property, securing the consumer's obligation, bringing such action only in a judicial district or similar legal entity, which is the same as which the real property is located. And if you look close enough at your paperwork in your court case, you'll see that there are actually 2 different names of courts being used. And the one where most of the paper isn't the real court, right? That's the one that's just the clerk's office type court. And so if you just took a copy of that and you sent it to these guys, said, would you look at this and tell me, is this, I don't believe that this court is in the proper jurisdiction for somebody to take my property. They brought the action in the wrong jurisdiction. Sure, you can go tell the judge and so forth, but I can just write a letter. Actually, you can do this all online with the FTC, and it doesn't cost you anything. You can send it in by mail. You can fill out a form online. You know, bada boom, bada bing. In the case of an action not described in paragraph 1, then go to number 2. Furnishing certain deceptive forms. It is unlawful to design, compile, furnish any form, knowing that such form would be used to create the false belief in a consumer that a person other than a creditor of such consumer is participating in a collection or attempting to collect a debt such consumer allegedly owes such creditor, when in fact such person is not so participating. Such as United States of America. They're really not participating, but we're going to put their name up there as the plaintiff. But of course, we all know that according to the Articles of Confederation, very first article, it says that the style of this confederation shall be the United States of America. And when you look at the plaintiff in a federal case, it is not the United States of America. It is United States of America. They're not the same. civil liability amount of damages, except as otherwise provided by the section. Any debt collector who fails to comply with any provision of this title with respect to any person is liable to such person in an amount equal to the sum of the actual damages sustained by the person as a result of the failure. In the case of an action by an individual, such action to damages court, but not exceeding $1,000. In the case of a class action, it can be more. Right? So the civil liability, the amount of the damage, because for them to get you the 3 times, it had to be criminal. And so this is just civil. At least I can get you back what. Well, so for me, all the years I paid the utility company, if they can't validate the debt, they've never had the franchise here, then all that money should come back to you. Everything you paid, all the interest. I think somewhere here they got to do like 7%. They have to add to it too, but I don't remember if it was in this or not. Factors, jurisdiction. Okay. An action to enforce any liability created by this title may be brought, in any appropriate United States district court without regard to the amount of the in controversy, or in any other court of competent jurisdiction within 1 year from the date on which the violation occurs. Well, who are they talking about, right? If it's not, what other competent jurisdiction is there? They say the district courts are, but, apparently, because these guys have their own administrative hearing board, their own administrative judges, well, that must be the other ones they're talking about, because that's where this is going to be heard, is in their administrative courts, under the administrative enforcement. The Federal Trade Commission shall be authorized to enforce compliance with this subchapter, except to the extent the enforcement of requirements imposed under some other parts, blah, 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 blah. Things to do with banking, right? But we're not going after the banker, because the bank didn't bring the charge. The bank has really never been involved. They've always been fictitious names, in my opinion, as far as the bank goes. Not that they're not involved. They're just not directly involved. Not under the name that they have for their, corporate being. But more on that later. For the purposes of the exercise of the Federal Trade Commission, of its functions and powers under the Federal Trade Commission Act, a violation of this subchapter shall be deemed an unfair or deceptive act or practice in violation of that act. So that's all you need to really say, is that you're pointing out a violation of this subchapter, and the subchapter is whatever the name of the act is, and that is an unfair and deceptive act of the Federal Trade Commission Act. I don't think we got to be too legalistic in our wording, right? I guess what I'm saying. Say, hey, we're just going to tell them I don't believe this to be proper. You give them a couple of things. You give them just enough probable cause, and then the commission is supposed to have the administrative law judges do the investigation. They're investigators. But this is the other people that might be involved, right? And it ends up being, because these are all to do with banking, by and large, the comptroller of the currency, or the Federal Reserve Board, maybe? I don't remember exactly. But for myself, I'm not going to worry about all these additions, or, these people have it over this, and these people have it over that. I'm going to send it to the FTC and see what they say. Right? Because if I'm not correct, they'd have to say, well, no, we don't have jurisdiction. You would have to give it to these people. You just can't tell me you don't have jurisdiction. If you tell me you don't, then who does? Because if you know you don't, then you must know who does. For the purposes of exercise of any agency referred to in this subsection of the powers under any act referred to in the subsection, violation of any requirement imposed under this subsection shall be deemed to be a violation of requirement imposed under the act. Blah, 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 blah. Yeah, you can get in trouble for a lot of things. But that's an interesting thing about this agency. That is what Consumers Energy, or your utility company, your cable company has gotten you to do is they get you to sign a piece of paper and they become your agent. Now, in Michigan, it says in the Constitution they have to have a franchise. Pretty easy to see. It wasn't so easy to see in Illinois because they don't do it quite the same in Illinois. And Roe lives in St. Charles, and St. Charles has a municipal power company, and and you start looking at it, it's like, well, this is, what's going on here. But when you read the name of the power company, and then you look at the application that you're going to fill out at City Hall for your power, it doesn't have the same name of the company on it. Right? So one says, something utility, and the other one doesn't. It's not the same company. And so you went to this other company, and now you just gave them agency. And so I gave Consumers Power agency, and Roe gave the whatever this entity is that's in City Hall agency over her power. Basically, you gave them power of attorney, and so now they're going to control whether you have power or not, or get the service based on the fee they're going to charge you for them to administrate this for you because you made them your agent. It's our agent's fee. Crazy stuff, ain't it? Reports. There was one other thing. Exemption to the state regulation. The Bureau shall, by regulation, exempt from the requirements of this title any class of debt collection practices within any state if the Bureau determines that under the title, the state that class of debt collection practices is subject to yada yada yada. And I looked that up, and they're talking about, like, Maine has written their own subsections that would fit into this law. And it goes from, the great thing is it goes from subsection 812 back up to 803, which is pretty much all the stuff we just read. But what it doesn't cover is the civil liability and who has jurisdiction and things like that. Just what people are called, maybe, or what a definition is, that kind of stuff. But it had to have been approved by the FTC, by the Bureau, and the Bureau was defined at the beginning. I'm not going to go back up and see which one of them is the Bureau. But you could simply email the Bureau and say, hey, I'm in the state of whatever. Per 817, does my state have an exemption? I'm sure they'll tell you, or tell you where to go look. Right? So if they don't, then what you saw here, just as it reads, is how it would apply. If they did, and you're in those states, you may have to reference their subsection numbers and say that they apply to this act. Right? But again, we're going to be bringing it to the FTC, and we'll see how they want to handle it. I mean, they could do the same thing. All we're trying to do is give them probable cause to say you need to go investigate this. And here's why. Okay. Hang on here. So that was what all this was. I just pretty much read this there instead of here. But here's those other agencies that we're talking about. The Comptroller of the Currency and the Board of Governors of the Federal Reserve System. 2, 3. The Federal Depository Insurance Corporation. The Director of the Thrift Supervision. Right, they would have jurisdiction in certain areas, but we're not really going after the banks. The bank isn't the one foreclosing on you, and the bank isn't the one that was probably ever the lender on the paperwork. I mean, has anybody ever looked at the lender on their mortgage paperwork and actually took the name and see if that entity exists, has a license to do business in your state? I think it's a fictitious entity. That's my point. The bank never lent you anything. And the governor of Illinois, he says that the Supreme Court is corrupt. What's the chances the judges under them are corrupt? Right? All organizations take on the character of their who's ever at the head. And if they're corrupt, they're all going to be corrupt. Okay, that's give me just 1 minute here. Okay, this is the Federal Trade Commission website, Protecting Americans' Consumers. And I'm not going to spend much time on it. I highly suggest everybody comes and takes a look at it and look at the things under enforcement, get an idea what it says there. I'm just going to show you what you would do if you wanted to put in a complaint. Submit a consumer complaint. Well, again, what's a consumer? Anybody who is alleged or owes a debt. So somebody send you a bill, that just made you a consumer. You can complain. Apply for a refund in an FTC case. That's interesting. I haven't looked at that yet. How do you get a refund? Report identity theft? Yeah. Your proper person has been stole. Right? Well, we'll look at that when we get to that part. But because the United States standard certificate of live birth isn't what you have, you were never properly registered as a citizen of the United States or a national of the United States, if that makes you feel better. And so you're stateless. And that's why your civil rights are being impaired. Civil liberties, excuse me. But we're going to just look right now at, well, there were two things on here, though, because there's a separate place for antitrust. So this is to file a consumer complaint, refund, identity theft. Well, I do want to find antitrust because you damn thing. Oh well, I'm going to find it later. Well, here's a guide to antitrust laws. But if you look on here, they have a separate place to send your antitrust other than a consumer. But the consumer complaint, this is the things that have to do with the debt collector that we just read, right? So that's what most of us are interested in. Go take a look. How can I submit a consumer complaint to the FTC? Well, the answer is to report fraud, identity theft, or unfair practices. Visit this link. That's easy enough, right? What else do we have here? Oh, here it is. Report an antitrust violation. Just to go look, so I can say that we have, it takes you here. How can I report an antitrust violation? What's antitrust? Well, coercive monopolies antitrust. And I'm going to show you that the name on the W-9 that they give you isn't the name that they do business under. And so somebody does not have a EIN number. And there's a federal law that says they have to have. If you have a question or comment about an antitrust issue, submit to the Bureau of Competition by one of the methods below. All right, so antitrust goes here. But we're going to go back to, I just want to do this one. So there you go. Alert. Click here to report someone falsely claiming to be from the government, a business, or a family member. Okay. Or you could click here and do it for identity theft, or you could click here and do it for scams and ripoff. So this identity theft, this could go against the hospital that didn't do the right form or didn't do the right thing and stole your damn identity or helped get it stolen, because it's on this initial form that they send that information to Social Security to set up your Social Security account. It's yours. They're administering it because you've never shown up. That's because the name that's on it isn't your name. It's the name they put on their fraudulent certificate of live birth that they're trying to get you to believe is the correct one. But when you understand, when you read what it is, that would actually be saying, well, I was a child of unknown parentage. Because on the one, it says they want the mother's maiden name. And on the one for the United States Standards Certificate of Live Birth, they want the name after first marriage. They're admitting you're married. You put the name down there, well, you would have been married. So, covered that in my last video. Not going into any more right now. These are just the different things you could do. And so this just kind of categorizes it. But scams and ripoffs, this would be for a foreclosure. I'm going to say alert, this one up here, this is if you got a traffic ticket or a summons or something to do with, well, summons could be for the scams or ripoffs. You got a traffic ticket or some other violation bordering on criminal. But no matter what, when you click on them, it just starts this thing. So you don't really see what you just did, but you've kind of put it in a category. But it doesn't really change what I asked next. What getting started. Did the person pretend to represent or to be a representative or employer of local, state, federal government? Yes. Okay, so now in just a few moments, you will be able to tell your story, blah, 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 right? So now they want you to give them some other things first. Well, what did I just do? All I'm going to do is I'm going to say, because they asked me, well, let's see what else we got. Pretend to represent a employer or business, pretend to be a family member or friend, pretend to be associated with the company offering to remove or virus or software, blah, blah, blah. How about pretend to represent or employee of state, local, federal government? That'd be like the guy that just pulled up behind you with the bubble on his car, who's going to get you to sign some piece of paper and create an obligation that didn't exist before, and he's not going to do it properly, so he's involved in fraudulent activity, creating a debt where one didn't exist before. So complaint and details. Well, that would be be you, but it says now you're not going to be. You don't have to answer all these, right? So it doesn't have to have anything to do with money. How much we asked for? Nope, nope. Did you pay the company? Nope. No, no. You just kind of bluff past all these, I guess, because a lot of that stuff I don't even see why I'd have to answer. Company represented a first name? Because I didn't say it was a company. I just said it was the government. Why are you asking me if it's a company? But if I was going to say it was a company, then I would say, well, what company is it? It is, if it was the sheriff, it would be Kent County and their address. If it was the city, it may Greenville, Michigan, or Greenville, city of Greenville, and its address. That's the company. I guess what's at the top of the ticket when you get all done? Right, company details. Well, okay, that's where this would go. Your information, right? Don't be shy. Let her fly, man. Let her know who you are. And then finally, now it's a chance to tell your story, right? You got 3,500 characters to tell your story, so keep it short. Then you can review your information. Now, I don't know that you can do any attachments or not, but if you could, right, it would be good to have, if you're going to be able to attach something, to attach it to it. But they didn't really ask for any evidence. They just want you to, tell them what you can, and I'm sure they're going to contact you, right? So be ready to be contacted. And, we'll see what happens there. But whatever they say, well, are you telling me that they didn't commit a crime? Just whatever your answer is, brother, put her on writing and send it back to me. Right? Make sure you put your seal on it. Okay, so this is the site. That's how you do a complaint. You could do it against, right now, here today, you could do it against things like traffic court cases or IRS cases, because the attorneys in the federal government aren't following the law either, right? And I'll show you some of that here in just a minute, because that's where we're headed next. I don't really have anything else to show you on this site, so just that it does exist. So give me just 1 minute again, and I'll be right back to you. Okay, I got bits and pieces scattered all over the place, so it's hard to keep up with everything. But I'm going to show you a few things that I believe led the governor of Illinois saying what he said, and It was, by asking them a lot of questions. And so I've shown this one before. This was an answer that Roe got March 20th. I remember the governor made his comments on the 8th of April or something like that, 2015, March 20th. Rosita, I have your letter inquiring whether an attorney licensed in Illinois may offer legal services to the public under an assumed name. I regret that I cannot advise you in this matter. Well, that would seem to me to be kind of like antitrust. Right? You're not telling me that you, the Attorney General, of course it's not attorneys general, but the Attorney General, can't tell me, or Roe in this case, right, if it's okay for an attorney to use a name other than the name that's on their license. That was what the question we're asking them. Right? So that was interesting. And we had also contacted the Office of the Inspector General, the Executive Inspector General, which, you would think this is the guy that's going to talk to the governor, for the agencies of the Illinois governor, asking the same kind of questions. In fact, put in a complaint. And this was the second answer. Upon review of your complaint, the Office of Executive Inspector General has determined that the nature of your allegation is such that it is more appropriately addressed by the Secretary of State, Inspector General. The OEIG works closely with other inspector generals, blah, blah, blah. Well, we thought sometime we had something going there, and it kind of fell apart, but it doesn't matter, right? This was information that was sent. But this was very telling. Please be aware that there are stringent whistleblower protections provided in the State Officials and Employees Ethics Acts that prohibit retaliation against those who make good faith allegations of misconduct. They will never do anything wrong. They will never harm you for telling the truth. You're doing it in good faith. Now, all I can say with this, although I don't remember if Roe swore to this complaint or not, was good faith would be if you would swear to it. Right? Maybe we didn't swear to it. All I know is if you're making good faith allegations, there is stringent whistleblower protection. They're not going to bother you. That's why we do these things and we don't get bothered. Praise God. Hallelujah. It's His protection. Right? We got guardian angels. I love my guardian angel. I wouldn't be here if it wasn't my guardian angel. I love my guardian angel. But we got to quit thinking that it's all the devil. Now, that it may be overlaid right now with the devil because Adam never kept the devil out of the kingdom, and that's what our job is. We're the new Adam. We're supposed to kick his ass out. We're supposed to conform the temporal order of the world to the will of the Lord so we can make the earth like the kingdom of heaven. And in the kingdom of heaven, they kick the devil out. We're supposed to do the same. We're the sons of God. We're supposed to be doing the same thing. And this was interesting. January, we had asked the name of the Kane County Criminal Division Chief, okay, and the county officials who are commissioned by the governor, because that's what the frickin' law says, right? That the county officers are commissioned by the governor. But this guy said, your request is granted as follows, blah, 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 blah. Secretary of State qualifications of county officers, November 2014, and close. Please note, the Secretary of State issues commissions, not the governor. Well, I don't have it here in front of me, but I can tell you that that isn't what the law says, or not. It's not what the Illinois compiled statute says. It says it's the governor that issues the commissions. And yet, in this thing here, it talks about all these, so number one, this just shows that these people are supposed to have these commissions. Here's a commission. Here's a commission. Here's a commission. Here's a commission. I don't remember. And these are all saying that they're these commissions are from the Secretary of State. Right? So, the guy wasn't lying in this book. That is what it says. However, in the Illinois compiled statute, it says it's the governor. So it's like, well, is the governor and the Secretary of State the same person? Inquiring minds want to know. So these were the kinds of things we were throwing at them um, at the time. And January 15th, the Judicial Inquiry Board received your complaint against Illinois State Court Judge. The board will discuss your complaint to determine whether it has jurisdiction, and if so, whether an investigation or other board action is warranted. Kindly be advised that the board's action does not include legal assistance or intervening in any court case. I think we'll get the FTC to do that from now on. Right, but, and again, we were pointing out that the judge, because in the Illinois Constitution it says to be a judge in the circuit court you have to be an attorney licensed to practice law within the state of Illinois. And that isn't the name they're using on their damn paperwork. So they're not an attorney authorized to practice law in the state of Illinois, therefore they can't be a judge. That was the complaint. And come April, the frickin' governor's talking about corruption in the courts. Now, he wasn't saying he wasn't corrupt or the rest of them. He just saying, well, they are. Yeah, they're part of a corrupt system. So is he. The whole government's a corrupt system because it's been overlaid with this coercive monopoly, the corporate state, which doesn't let anybody be properly elected to hold the de jure office to have any frickin' power. Right? So if you want to get a remedy, it's not going to be in the state because they ain't there. Go to the FTC. So in my case, with the utility, I was going to go to the Michigan Public Service Commission. But after my first attempt at getting information from them, it's like, well, here we go again, right? Ask a question, get a stupid answer, come back with, well, that isn't what I wanted, I want this. And then the next one they give you is just, words with blank paper, no signature, no nothing. Still not giving you what you want. So, okay, so anyways, these things I have here are all over the place for all sorts of things, and they're not going to be in necessarily any particular order. I'm just going to do the best I can as I remember what I have them here for. But for instance, in a foreclosure, right, someplace there's going to be a piece of paper talking about the dude who's the attorney of record. Right, so attorney for plaintiff is this Reagan Lewis something or other, ARDC number. And of course, if you take that number and you go look at Reagan Lewis, you'll see that Reagan Lewis on the ARDC is in Illinois, the Attorney Registration Disciplinary Commission, that Reagan has got a middle name, but he isn't using it here. So he's not doing it as an attorney. And it gives the address. So this is who I would say he's representing the plaintiff, supposed to be. This is who you would contact to get validation of the debt per the Act, right? Quoting the section of the Act, per whatever this, at the very beginning it said cite this as the name of the Act, per this name, you're requesting that he comply with section, whatever the section was, that says he needs to validate the debt. And the 5 things he needs to do, and just copy and paste it, put it on there, say please do this, and I'll wait to hear from you. Well, you should not hear any more from him ever, but if you do, well, then he's just violated if it's anything besides validating the debt. Okay, so I'm just saying this is what you're looking for. You're looking for the attorney of record in a foreclosure. At least that's who I would send it to. This is, we had asked for the bond of the prosecutor for the county of Kane. Call him state's attorney, actually, right? Joseph Henry McMahon. Now pay attention to this. The principal and the surety hereby consent to changing the attached bond as follows. The obligee name and address are changed to the following. Okay, so the obligee, people of the state of Illinois, is just part of it. The people of the state of Illinois, county of Kane, comma, C-O, Kane County Public Officials, comma, 719 Batavia Avenue, Building A, Geneva. That is the name and address of the obligee. Right? So the obligee is actually the people of the state of Illinois, County of Kane, care of Kane County public officials. But all they put on the frickin' paperwork is people of the state of Illinois. Right? So that's the obligee. So this is supposed to have something to do with this guy's bond, right? That somebody asked me if I'd ever seen a bond. Well, when you come down here, the obligee, who do we say they were? This people, state of Illinois, Kane County. They never accepted it, right? So this is a simulated legal process. They're simulating this to be a legal piece of paper, saying that Joseph Henry McMahon is bonded or licensed, bonded, I guess we would say, to be the frickin' county prosecutor, state's attorney, as it were. Because here they got it. So here's the bond, right? So now this is the bond for the one was a rider to the bond. Now this is the bond. As he's the principal, and the Ohio Casualty Insurance Company, a corporation organized existing in the laws of the state of New Hampshire, but we're going to call it the Ohio Casualty Insurance Company, hereinafter called the surety, bound unto the people of the state of Illinois, Kane County, comma, right? There it is. That's the obligee. Not just the people of the state of Illinois. It's people of the state of Illinois, County of Kane, comma, C/O Kane County public officials. And they tell us the people of the state of Illinois. No, it's not like that is the government. If the state's coming after you in a criminal matter, it's going to say the state of Illinois on it. That's who brought the charge. The people of the state of Illinois never brought anything. But this corporation, named the people of the state of Illinois, County of Kane, care of Kane County public officials, they did. Right? So this is where they took the body politic, body corporate, and fused it into a coercive monopoly. So, but is this correct? Let's see. So that's good. Good. I don't remember if this was right or not. If this guy actually had, I don't believe that. It seemed to me there's something missing on this, right? So, maybe someday I'll go back through it and find it. But there is a problem with something on it. But this is the guy's bond. Well, and the problem was that not on this page so much. Whereas said principal has been elected or appointed, right? So where's his election or appointment paperwork? To the office of Kane County State's Attorney. But you see, the Kane County State's Attorney isn't the county attorney for the body politic. It may be for the body corporate, if they want to call it that, but it's not for the body politic, because the body politic is the county of Kane, not Kane County. I'll show you that in just a minute. So that's what one looks like, right? There's a bond for a guy that's supposed to be the state's attorney, but he's not the attorney for the body politic. And the obligee never accepted his extension, his change rider. Okay, so I won't spend more time on that one, but you get the idea. Let's go look at some other things. We're talking about Kane. I got lots of information on Kane. This is supposed to be a copy of the bond for the... we asked for the bond for the county clerk's bond. County clerk's bond. Blah, 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 blah. Okay. And here's his. which had same thing. What was it about these that was incorrect? Well, John A. Cunningham, first of all, they took his name out of there. Whereas the above principal has been duly elected and appointed the Kane County Clerk. But again, this has nothing to do with the government, because Kane County is not the government. Right? This is a private corporation, basically. Because Kane County is a vendor. Right? Here's a vendor contract that Kane County has with the comptroller of the state of Illinois to give out flu vaccines. Right? Well, they're a vendor. I mean, that's not acting like a political subdivision. That's like a vendor getting, we'll go do that for you. We'll offer that service. But this is the really telling thing, and it's on page 15, where it says, hope you can see this okay. Let me get this. The County of McHenry, this is an intergovernmental contract, by the way. The County of McHenry, a body corporate and politic of the state of Illinois, acting by and through its Division of Transportation, hereinafter called McHenry County. So McHenry County is the Division of Transportation of the County of McHenry. The County of McHenry, not County of McHenry. The County of McHenry. That's the body politic. The County of Kane, the County of Kane, is a body politic, corporate politic of the state of Illinois, acting by and through its Division of Transportation, hereinafter called Kane County. And the village of McHuntley. So they're all the, right? These are all thes. Village of McHuntley. Municipal corporation of the state of Illinois, hereinafter called the village. Yada, yada, yada. See, now that's a municipal corporation. Well, there you go. It's a corporation. Sounds like it's a coercive monopoly corporation. And these other ones aren't. Kane County and McHenry County, they're not the political subdivision. They're the Department of Transportation. But that's what you see in all the signs. Okay. Let's say you're involved in a court case. Right? So let's look at some of the things we might have seen and why it's important and what you can look for to say, well, this isn't correct. So first of all, when Roe got popped for disorderly conduct because she happened to ask the county recorder a few more questions than she wanted to answer, she ended up getting this complaint put in against her. Or so it shows, and it's gen number, whatever, and, didn't put it in her proper person, right? Put her in her last name first, although she gave them her state ID, which has her name the other direction. This is how they put it on there. Said the complaint was Sandy Wegman, who's, that's the state registrar. Disorderly conduct. Right? They cross this shit out here about appearing. This is what, they did. This is what Roe did. This is what they did. Now, Roe never got a copy of this. She actually had to go to the sheriff's department to get one. Right? And see, it has this gen number. But then later on, we found where they had put one in the court case, I think. But it doesn't have a gen number. Instead, it's got a court case number. Right? But this one was imaged and put in the court. See, this one's in the court case. They never put it in the part where she could see it until she complained that there was no charging instrument in her court case. And I guess they really got pissed off they had to do this, right? But so this isn't exactly this. I mean, this isn't the same as this. It's close. I mean, you can see they have holes in it. It's a multi-page form. But they must separate it and do some pages on, separately because you don't see any marks on this where it has the 13 CM 3431. Nevertheless, also note that this is in the circuit court for the 16th Judicial Circuit. Right? A lot of the other paper we're going to see is going to say in the circuit court of the 16th Judicial Circuit. Those would be two different courts, but this is the one that she got charged in, apparently. It's the for the 16th Judicial Circuit. And it was for disorderly conduct and no need to appear. So they said. Right? So if you've had a case against you of some kind, if you went down to the sheriff's department, you might be able to get this. Something like this. But because this looks like, the foregoing complaint is subscribed and sworn to before me on this the 7th day of August, right? That part was done, right? The problem for them is this form is unauthorized. And so is this one. And it's going to be the same pretty much everywhere you go because most places have some kind of uniform citation they're supposed to use. And this is what the citation looks like in Illinois. And so if I went back and we looked at okay. That's what Roe has. Badoom, badoom. They don't look the same. And when you go read the law, it says it will be the same, right? They shall be incorporated. So they didn't use the form, right? This form, the difference is this form here has been approved. Okay. The enactment of some act reduce the speed for which a driver could do whatever he's doing and assure performance of the act. The Supreme Court made corresponding amendments to the bail rules filed whenever. The Conference of the Chief Judges at its meeting approved changes to the Uniform Citation Complaint Form, perspective of the court's approval on behalf, yada, yada, yada. Anyways, in Illinois, they have to use this form. It's a form they got to use. It's not what they used. Now they have another one that's for like, what do you call it? Natural resources type things, but it's pretty much the same. And so this is what it says about it. First, one of the things this is where they get you that these are the Supreme Court rules of Illinois. Traffic and conservation offices for which court appearance is required. A court appearance is required for a violation of any ordinance of any unit of local government defining offenses comparable to those specified in blah, 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 this rule. Right? The violation of any ordinance, you have to appear. But you need to appear in the ordinance court. Not in the not in the other court where they're going to have you appear. So you don't go take care of the ordinance violation. You don't appear. They say you didn't appear, and now you're in contempt of court. And the court that you end up going to for your first hearing, you're actually there because you're in contempt of court because you never appeared to the initial court appearance for the ordinance violation. So what does it say about uniform ticket? Uniform citation, complaint forms, and conservation complaints shall be in the forms which may from time to time be approved by the Conference Chief Circuit Judge and filed with this court. The uniform forms shall be adapted for use by municipalities. The arresting officer shall complete the form or ticket within 48 hours of the arrest, transmit the portion entitled complaint and disposition report, and where appropriate, to the clerk of the circuit court those were all the things they were supposed to do, and they're supposed to do it on the proper form, which they didn't do. Now let's see if they did it in the right amount of time. Did they even get that part right? Okay, this was done on the 7th. And this doesn't show anything that it was ever put into court. It's supposed to be done within 2 days, right? So it'd be out by the 9th. But this other one here, this got a court filed on date on the 19th. 19 minus 7 is 12. Is that more than 2 days, 48 hours? I would say it is. I would say by now they're simulating a legal process, and it would be time to get a hold of the people of the state of Illinois through their, of course, Kane County, right, is the one who brought this charge, because it was the Kane County Sheriff's Department that picked her up. Probably to the state's attorney and say, validate the debt. Or send it to the, just send the copy of the complaint, just like this, and send it to the commissioner's office and say, please validate the debt. Any more attempt to collect this debt may lead to filing of a complaint with the Federal Trade Commission. If you determine there is no debt, please remove the record. And give them a chance to do the right thing. But right now, I mean, they're screwed, blued, and tattooed. Let's see what we got here. We had some other. Okay, so now this is what they get you with. So they did this complaint that Roe didn't get, right? This was done, on the day that it happened, the 7th of August, 2013. What Roe got was this. And they like to refer to this thing as a certificate of defendant. Right? So Roe had to sign this thing on 7/13. Right? That's Rosita's signature. She did sign it. They said you can't leave until you sign this piece of paper. Right? Well, what this is, it's supposed to be a bail bond form. But they never call it a bail bond form. They only ever refer to it as a certificate of defendant. And one day when Roe had to, go to court, she's there sitting and just watching these other people go up. And all the judge would do is point to this piece of paper where that signature is and say, is that your signature? Right? Yes or no? Well, you say yes, well, then you owe the debt. If you say no, well, we're going to find out if you owe the debt. But when you read this certificate on here, I, the undersigned, defendant, do hereby acknowledge myself to be indebted to the people of Illinois or the city or village set forth as the municipal corporation in the sum indicated as bail. So, they're saying, Roe's just saying that she owes them $1,200. She owes the people of the state of Illinois, city or village of, $1,200. Okay, well, that made her a debtor. And now they're going to try to collect this debt. It makes them the debt collector. Even though you thought you were in court. It's debt collection. Using a simulated legal process and color of law to do it, which makes it antitrust. Because basically for what Roe was, now here's the thing. Offense D.C. That's unacceptable. She wasn't charged with anything. There's no charge been made. And for what this is, it's a Class C misdemeanor at best, and it was supposed to be a $120 bail, not 12% of $1,200. In the law, it's a $120 bail for a Class C misdemeanor. They filled the paperwork out wrong. Final disposition noted on the reverse side of the complaint shall be evidenced. Oh, that was the other thing. So this other one, wanted to look at this, see if it called itself the complaint. Yeah, it does say complaint. Okay. That says complaint, but that isn't like this one here that says it's a complaint. They actually have different words on them if you got down and looked at it that close. Or They're different. Um, okay. So I said one last time, right? The circuit court, in the circuit court for, in the circuit court of. And now we're just down to the people. They got her name right, so this is just, one of they say this is an order from that court. It doesn't have a court seal on it, so it's not a court order. It's just somebody's private opinion, because the guy who's acting as the judge in this case isn't doing so in his proper person, so he's really not sitting there as the judge. But just to show you that this paperwork we're looking at, a lot of this, it'd be the same in this, I'm sure. The of court, not the for. The complaint was on the for, but you're in the of court. And there's no records being kept. So this is, again, this is what this looks like. Now, if you were to read the rules, what it should look like is come on, baby. It should look like this. I mean, this is closer. Bail bond, certificate of defendant. Right? This one says it's a bail bond. I don't know if they try to sell this as a certificate of defendant in this county or not, but it talks about the notice being in a larger font and so forth and so on, and things being separated from each other, and this looks a lot closer like it should be. But the one they got roll with is certainly not what they were talking about, and so it's it's a simulated legal process. Now, again, this thing here, it talked about that there's these forms that have been approved by the Conference of the Chief Circuit Judges and filed with this court. Okay, well, here's some examples of what they do, because they do things. Here's one here that says it's approved, form approved by the Conference of Chief Circuit Judges. Good enough for me. But it's in the name of the Circuit Court of Illinois. It doesn't say 16th Circuit first. No, it says the Circuit Court of Illinois, 19th Judicial Circuit, Lake County. That's the proper name for the de jure court, in my opinion. The state court. All this other shit are county courts or legislative courts or whatever they are, and this is the state court. Circuit Court of Illinois, because there's only one circuit court. That's what it says. There's only one circuit court. It's got different circuits or divisions in it, but there's one circuit court. Right, that was that one, and there was another one someplace. Another one, Circuit Court of Illinois, 6th Judicial Circuit, and then the name of the county. And these are both for, petitions of orders or petition for protection. So it would make sense it would be the proper one. And it's approved by the conference. So when the conference does it, it says Circuit Court of Illinois at the top. But when you go to court in Illinois, it says in the Circuit Court of the 16th Judicial Circuit. It doesn't say Circuit Court of Illinois, 16th Judicial Circuit, Kane County, Illinois. Then this isn't the court they're talking about. This is the black hole court. Okay, so that's just just the kind of stuff they put on paper that just blow you away. In the Circuit Court of, another one. All these things are in this other court that doesn't exist. So it's evidence that they're trying to collect the debt in the wrong jurisdiction. And was there one other one? The of court. No, I had one other one in here. Uniform citation, arrest warrant, certificate, Sandy, or approve, Sandy, nope, that's all of them. Good enough. Okay. Now in Arizona, what they did there is this is the ticket that Bobby got. And this is the, excuse me, this is what it's supposed to look like. All right, so they have a uniform Arizona traffic ticket and complaint form. And this is what it looks like. And it has particular words in particular places, and one of them particular places is where it says I certify with particular words, and that's what you should be certifying to. I gotta close some of these other ones up. Bob's, though, now if we just look at the bottom, we're going to just notice, without doing anything else, that these forms are different. Let me get rid of this. Right? This got docket number, disposition, blah, 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 blah. Got that crap in there, right? What does this say? Violation 1, violation 2, violation 3. It's different. Without anything else, it's different. But it gets even more different when you get down here. It's I certify that upon reasonable grounds, I believe the defendant committed the above violations, and I served a copy of the complaint upon the defendant. And this one here says, I certify upon reasonable grounds I believe the person above named committed the acts. Didn't say anything about a violation. An act isn't a violation. You didn't violate anything described, and I have served a copy of this complaint upon the defendant. All right, this one said violation. This one says acts. They're not the same. You must appear. I think that part's different too. If you were to look at that, you're going to see that that's different. You must appear at Surprise City Court, court number 0761. As it turns out, this is a special office inside the building, not the door you walk into. It's actually somewhere else. And the date and time indicated. Now, the other thing is, Bob was supposed to sign this for criminal, and he didn't sign it. Officer Cody signed it, but this is what the defendant's supposed to sign. So if you got a ticket like this, it's obvious that it's, that's fraudulent. It's a simulated legal process. And to me, it's just evidence that they committed a crime. I don't know that I need to go back to the Surprise Police Department, but you could. Right? They're the one who gave it to you. Please validate this debt. If you don't validate the debt, I'm going to take it to the Federal Trade Commission for antitrust activity. Take it to them anyways. Just say, I believe this to be antitrust activity. I got this ticket that it doesn't look right. That usually the officer doesn't sign in his proper person. That's almost always the case. In Michigan, it looks like they even use the right form, but they never sign in their proper person, right? And so, if you don't sign in your proper person, well, then you need to go before a magistrate and swear out your complaint. Otherwise, it's not a complaint. And they put like Officer Smith or Officer Frank Jones or whatever. Officer is not your name. It should be the name that's on their oath or on basically their commission. Whatever they were commissioned in ought to be the name. So here's another one, right? Here's, again, a traffic ticket. Boom. This is something to take the FTC. Oh. Okay. See page 20. Okay, this is a CAFR account. Paperwork, right? Consolidated, comprehensive accounting, something or other. Decided to go to page 20. The reason I wanted to go to page 20 was to show you that if you were to, read these things and look at them a bit, you find out all sorts of stuff, like note 2, cash and investments, right? Now, these investments are like cash. So this is cash on hand. This cash on hand is what one school district in Illinois has. Just one. At June 30, 2012, the carrying amount of the district's deposits, excluding student activity funds, of $823,000, we'll give the students $823,000, which included both cash and certificates of deposit, CDs, totaled $81,882,368. Do you think they need any more money? They got $82 million in the bank. This is just cash on hand. This has nothing to do with the rest of the net assets. This is cash. Cash in a bank for one school district, and they're going to want to raise taxes for schools. Well, how can that be? Well, it's because these people aren't properly elected. Right? So it's, again, it's an antitrust. It's a coercive monopoly that's taken over a government office, because that's what school districts are. You got to run for office, and you got to be properly elected, and you got to have a certificate of election, and you got to have all the things that it takes to be elected. If you don't, you're not elected. If you didn't file a bond and it says you're supposed to, you're not bonded. If you don't file a valid oath, it's not a valid oath. I don't care if it says oath on it. Was it done by the law to be an oath? If you don't have any of those things, it doesn't matter if it's the school district or all the way up to the U.S. House of Representatives, you're not holding the office. And this company here, Klein Hall and Associates LLC, is not a licensed CPA, certified public accountant. And therefore, they can't do any government auditing standards. You need to be certified. And they're not, so they're doing business without a license. You could take that to the FTC and say it's antitrust activity. Right? So go look up your school and on around, and you're going to find, you can pick on this right here. Just go to the page, the very front part where the blah, blah, blah is from whoever says that they're doing the audit, and then go look on your state's license website to see if you can find them. Or contact them and say, I need a copy of your license. I need to see a copy of your CPA license, please. They can't give it to you? Okay, so now we're not talking about debt collector to you. We're talking about antitrust against you by a coercive monopoly, because they're going to raise your taxes. Now you're doing it for the common good. It isn't just about you. This is for the common good. Let's see what else we had. So I did many videos on IRS stuff, but one of them was that for these people to be who they say they are, they have to have these determination letters written by the IRS that says the IRS agrees and acknowledges they are who they say they are. Now you can look at the way they put their name, Kane, Cown, Coms, this 303. That's the name, right? That's the proper name. That's probably what's on the frickin' EIN. I mean, this is their EIN number. Kane, Cown, Com, Dist 303. But it goes on to say, Dear taxpayer, this responds to your request for information about your federal tax status. Our records do not specify your federal tax status. Well, how can that be that it doesn't specify? It's because they never got a determination letter from the IRS to say that they are who they say they are. Our records don't say who you are. However, the following general information about the tax treatment of state and local governments and affiliated organizations may be of interest to you. They got a name for this letter. It's like the 7, what do they call it, man? The 7 something or other. Or no, 147 letter or something like that. Letter 47. Oh, I don't remember. But they give it a name. But these are things that would apply to the governmental units, and these are the different reasons you could be exempt. That's what they're showing right here. It didn't say these people are. It's just saying you could be. So this isn't a final determination for this entity. Their determination is our records don't specify your federal tax status. In other words, we're not saying that you are a tax exempt. We're not saying that you're the government. We're not saying you're a school district. You know, how can you tell that's a school district from that name? You can't. Because here, they went as St. Charles Community Unit School District 303. Now, this is going to the state asking for a tax exempt identification from the state, because the state does give identification numbers for tax exemption. And it says, we have issued the following new tax exemption number to St. Charles Community Unit School District 303 of St. Charles, Illinois. That whole thing is the name of something. It isn't just the St. Charles Community Unit School District 303. It's that of St. Charles, Illinois. So you got all these different names going around. It's like, well, there's something hokey going on here. FTC, could you look at these pieces of paper for me? Can you tell me if we're talking about the same people? Are they following the law? We'll go look at Kane County's CAFR, page 38. This is a long one, 300 and some odd pages. I don't want to read that much. What do I want to read about? I wanted to go right here. Total assets. This is the assets, right? So here's cash and investments. This is the same line where the school district inside of Kane County, just one school district, there's many, had $88 million or 80-some million dollars in the bank. It looks to me like, well, they got 233 here and another 16 here, and for a total of $250 million in a bank someplace. Oh, add to that the $50 million over here in the preserve. $350 million sitting in the bank. What do they need to raise taxes for? They don't. We could go on to find there's liabilities. What's the net position? Total liabilities, deferred inflow, total net position. Right, so net, right, that should be, when everything else taken care of, are you above or below the line? And there's $635.6 million to the good, in the black. But that's Kane County, Illinois. That isn't the government. The government is the County of Kane. Kane County, Illinois, if it's anything, well, Kane County by itself should be the transportation department of the County of Kent. County of Kane, excuse me. I live in the County of Kent. Got too many Kanes, Kents floating in my head. But again, and so these people had theirs done by, somebody who did theirs. A lot of blah, 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 blah. These guys. Weirmer, Rogers, Doran, and Ruzon. Guess what? They're not CPAs. Because this is the name of the company, right? Apparently. Because that's what they're signing as. And I don't know that you can consider that a signature even, but that's what they put down there. So that's not a signature. LLC, Certified Public Accountants. I'm afraid you're not. You're just an LLC. I did videos and I actually show these why they're not. I just don't remember off the top of my head why they're not. I'm not going to worry about it right now, but they're not. Let's see. Just a few other interesting ones. So what do we got here? Now here's the city of Batavia, which, interesting enough, they use they're using the complete zip code, the 12-digit zip code, of which two of these. So there's something about this last digit. The first two digits go to the last two digits of your street address. And then the very last one is some kind of identifier, and I've never figured out what it is. I just know there's a 12-digit zip code. And so, 60510-199 or 193100 is a specific spot on a map. It's almost like a grid coordinate or, GPS coordinate or something like that. It's down in your mailbox. The last four get you within 100 of your mailbox, and the last two put you in your mailbox. And so really that's an extension of the post office. That's the post office's mailbox. It says right on it's post office, right? Tamper with the mail, you get inside that. So if something goes in there, well, that was just using the mails. Thanks for your response. Please keep this number permanent. You should, so they're saying that this is the number for City of Batavia Financial Department, because these two go together. Right? It's not the City of Batavia's, it's the City of Batavia Financial Department's EIN number. They're simulating being the City of Batavia. The county does the same thing. Right? County of Kane, Kane County Treasurer. That's how your bills come for your property taxes, if I'm not mistaken, Rusky. Same thing. Yep, this is the EIN of the County of Kane, Kane County Treasurer. What we would think of as being the County of Kane's EIN number. And then we got the County of Kane as the treasurer going to get a number for the County of Kane of Geneva, Illinois. None of these say the County of Kane, right? It's County of Kane. So none of these are really the political subdivision. I want to show you on page 20. I wanted to show you something here. See, here's their W-9. They put the County of Kane. They're not putting their whole name, right? Because the County of Kane, comma, the treasurer has this number. So when they give you a W-9, they're lying. And they just lied on a federal form, and they're trying to pass it off as a official form, and for that reason, it's antitrust, or it's or you can say it's coercive monopoly, or you can say it's debt collector not doing it properly. But these are the people trying to collect the debt. When you go to the county and ask them for a copy of their W-9, Roe got one in the name of County of Kane. I got one in the name of County of Kent. And so, where it has here, this U.S. person, there should be a seal for if it was the de jure county. Should have their seal there because that would be the U.S. person. Right? This guy here has nothing to do. If this is a living man person, then there should be a Social Security number here. Because this isn't his EIN number. It's the County of Kane's EIN number. So the dude committed perjury on the piece of paper. What else we got? I haven't looked at most of these in a long time. All right, now here's the W-9 for a place called the Forest Preserve District of Kane County. Did I do it twice? Yeah, I just did it twice. Okay. So I didn't copy the one but they have a different name on other, the paperwork they use has got a different name than this. So one of the things you're supposed to do, and I didn't remember to copy the form, but there's a form that you can send to the IRS to ask to see the paperwork for the formation of these supposed corporations. And so you can ask for their 1023 or 1024, which is the paperwork to get for a nonprofit to get organized, or it's their application basically. And then you can also ask for the determination letter. And that's what we're going to try to get, a determination letter. We already know what we're going to get isn't that they are who they say they are. They won't have done everything they're supposed to do. There's one other thing I wanted. What did I do with this one yesterday that was quite telling? Oh, okay. I know what it is. So the W-9 says the county of Kane. But let's, just because we can, Kane County. Kane County. And I'm just going to start clicking through on Kane County and see what comes up, right? Kane County Sheriff's Office. Not the County of Kane's Sheriff's Office, Kane County. Kane County, Illinois. Kane County, Illinois. Kane County Sheriff's Department. Kane County Board. Kane County Sheriff's Qualifying. Nothing to do with the County of Kane. Kane County Board Chairman. Not the County of Kane. Kane County. Kane County. Oh, Kane County. Kane County. Kane County. Kane County. Whoop. County of Kane. At Kane County Treasurer. Oh, Kane County Purchasing Department. Kane County. Kane County. That don't seem to have jack to do with the County of Kane, yet these people, that's who they say they are. That, it's the Kane County Sheriff Department. Sheriff's Office. Who the hell is that? Well, if Kane County by itself is the transportation department of the county, then the sheriff's department must be the code enforcement for the motor carriers on highways that are technically parts of interstate commerce. And so even though they're doing it in Illinois to you, giving you a ticket right there in Illinois, in Kane County, for instance, it's still federal because the road they're doing it on is a highway, and it's all interstate. Interstate, I guess I call it. But what I want to do is look and see then about County of Kane. Does it ever show up? County of Kane. Oh, should spell it right first, Bob. Oh, at the top, County of Kane. But not the County of Kane, just County of Kane. County of Kane, County of Kane, County of Kane. Right, they're mixing the two together all over on this. The County of Kane, right, the County of Kane is exempt from federal, state, and local taxes, which includes but not limited to sales, retail, blah, blah, blah. The County of Kane, not County of Kane, and not Kane County. But they're calling themselves the County of Kane, and that isn't the one that's tax exempt. But they're going to go get a tax exempt number for the treasurer. County of Kane, County of Kane. Not many, but there were some. Okay. What else I have? So let's look at. I had one here for federal court. Oh. Even federal. Let's look at this, right? This is this part of the paperwork that put some lady in jail for 4 years. When you go to this page right here, United States District Court for the Northern District of California. Remember the for the, because we're going to go one more page, and it just disappeared. United States District Court, Northern District of California. This is a different court than this is. This here should be the de jure. I mean, this should be the Article 3 court, before the court. Did videos on it, where it came from. I don't remember exactly, but I showed it, so it is. But everything that happened in it was happening in this other court over here. She never went to the court to answer the charge. They indicted her in this court. And so as we look at the indictment and so forth, what becomes apparent, because it's always at the end, is what did the attorneys do? And the way this works, this is federal, but all the attorneys who work in the federal departments have to be a member of whatever organization it is within the state that authorizes the licensing of attorneys. Right? So in Michigan, they'd have to be a member of the state bar of Michigan. So wherever it is, and so this is California, they had to be a member of the state bar of California. And you go to the state bar of California's website and you look these people up. They got middle names, but they're not using them. So they didn't appear in their official capacity. And we pointed this stuff out to the judge in this case. Where is that? And by sending it directly to the judge, like Melinda Haag, United States Attorney, Melinda, you got a middle name. You didn't use it. You didn't come as a United States Attorney. You're simulating a legal process. So, anyways, this is a bogus indictment. And done to collect a debt. So we're going to, I'm going to take it to the FTC, try to, and see if there's something we can do with it there. But, hang on just a second. I need to go do something. Okay. I was gone for a little bit there, so I don't really know where I left off, but I'm just about done with this page. In that this is a simulated legal process where the the government's attorneys aren't using the name on their license. These pages here talk about a criminal action, and the only this is from 1978. Excuse me. Now this case just happened. And this form is, revision from 1978. Well, they don't use this form anymore. Here it is as part of this court case. What it does do is it lists all these people who's involved. You got the name of the office or person furnishing information on this form. Melinda Haag, and she's supposed to be an attorney. Well, that's not the name on her attorney's license. And that's not Kelsey. Kelsey, you got a middle name too. You didn't use it. So, that's that kind. Now, there's one other thing. What I'm going to use as an example is the deed of trust or the mortgage that you find on Freddie Mac. Is it Freddie Mac's website? I believe it is. Right? These are like the uniform mortgage paperwork. And so this is where I'm talking about. See where it says here, the lender is, and it puts a name. The lender is a something organized, right? I don't know what they put on these, but you should read it and then go see if that's who they are. If they are who they say they are. Because I'm going to show you here that no one's ever lent you any money. The note means the promissory note. That's the other piece of paper. The note states that the borrower owes the lender, and the lender is this person up here. Right? So this lender is going to become if he's anything, if there's a creditor, it's this person, the lender. And so only the creditor can bring a claim against you. And so when you look at foreclosure paperwork and see somebody else's name other than the lender that was on the original piece of paper, well, then it by the Fair Debt Collection Practices Act, they can't do that. They're not the creditor. The creditor would have to be the plaintiff. I guess what I'm trying to say. And then the loan means the debt evidenced by the note, right? The loan is the debt evidenced by the note. Let's go look at a note. Here in just a second. Where is the note? I'm going to show you one that's been paid off, right? Here, in this case, they're saying that the Bank of America, N.A., successor by merger, blah, 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 right, of Countrywide Homes, or Country Homes Servicing, LP. Yeah, this long-ass name, right? But, okay, let's go look at, here's the attorney of record. Certificate of service, I hereby certify true and correct copy served electronically. Brock and Scott, PLLC, attorney for plaintiff. So here's who you would write to say verify the debt. What debt they going to verify? Well, here's an assignment of mortgage. I don't know who that was from or to, but you know it's an assignment, and we've been told, well, you doesn't make you the creditor. You've just been assigned to you. But it was an adjustable rate mortgage. The lender is Countrywide Bank, FSB. That's the lender, right? That would be this person right here. Or should be. But who's it's the Bank of America NA is the one foreclosing, and well, you're not the lender, brother. And you can't assign it according to the Federal Trade Commission. But not only that, look at here, they didn't put what city this was done in. And the biggie, let's see if you can see this. Pay to the order of, without recourse, Countrywide Bank FSB by somebody other. Right? This was deposited, turned into a check. Pay to the order of. And so once it went from being a note, which is a negotiable instrument, and converted to a check, which is what they did by putting pay to the order of, the debt was extinguished. There is no debt. If there was a debt, it would be to the lender. The lender is Countrywide Bank, FSB. Is Countrywide Bank, FSB, if that's what that says, was that ever the name of a company, or is that like, you know, really close to it, but not quite the name? Because if they weren't licensed to do business in your state, well, they couldn't lend you any money anyways. And that's the same with this mortgage, right? This is the piece of paper you're going to end up signing at some point. But the bank or the lender's never going to sign it. So it'll be a unilateral contract at best. And because the bank never signs it, all of your payments are going to go into escrow. And so you're going to keep making payments to the same escrow account forever. And the reason there's an escrow account is because the parties have never agreed to the contract. That's what escrow's for. Somebody to hold the securities or hold the deposits until the contract's been agreed to. But so is this a contract or not? Well, agreement means contract. Covenant agreement certainly means contract. And so this is a contract. It's a business contract, and both parties have to sign it. Agreement. On and on and on. Agreement. Until you get to the end. And on the last page, Bauer, right? Where you're going to Bauer, but there's no place for the bank to sign it. So it's not a business contract unless there's a meeting of the minds and both parties agree and sign. So you could sign this copy, say, all right, I signed it, and then they take it from you. The bank never signs it. The payments start going to escrow because that's what you agreed to do with this piece of paper. But you're waiting for the bank to sign it, and they're not going to sign it. And so you want back all the securities, right? All the money you paid on this, right? Because it's securities you're going to keep sending to them to some account, and it's your, it's sitting in an escrow account. It's your property, and so that's what we're going to go try to get back by saying, hey, the bank never signed the contract, or the lender never signed the contract. The thing is, the lender, I don't believe, is truly a bank, and that's the thing we need to. I need to see one of these to see who do they list as the lender, and do they give the organization? This is what Freddie Mac has on their website. Lender is of wherever lender's address is, right? That's what we need to contract. Say, hey, are we going to have a contract or not? Are you going to sign the contract or not? So, these are all things I pointed out before that you can find on their paperwork that shows that there's never been a loan, and you can find in your property file that the mortgage has been satisfied, a satisfaction of mortgage. If the mortgage has been satisfied, then all the securities are supposed to return to you, because that's why you gave them for. The securities aren't the mortgage. The securities are the security until the mortgage is satisfied. The mortgage could be nothing to do with money, and you were just supposed to do one thing. I don't know what it is. Take this piece of paper from this office and go give it to this office or something like that. Could be. But it's never been done, or they say it hasn't been done, and, let the games begin. It's all a simulated legal process using color of law. And as it turns out, thankfully, those are things that are not in keeping with the Fair Debt Collection Practices Act. You got to download yourself a copy of this. And just real quick, just because. Oh, consumer defined. I don't know. I want to go through all these again. Of all these false representations they're going to make. The use or distribution of any written communication which simulates or falsely represents to be a document authorized, issued, approved by any court, official, or agency of the United States or any state, or which creates false impression of its source, authorization, or approval. That'd be like an indictment, traffic ticket, those kind of things. False representation or implication that documents are a legal process. That would be the stuff they send you in your foreclosure. But here's what you want to get them to do, right? That's all for all this. It's the same thing. Consider them to be the debt collector. Say that you believe them to be a debt collector, and therefore you're under. Find that page again. The title may be cited as Fair Debt Collection Practices Act. So by the standards of the Fair Debt Collection Practices Act, Section 809, I ask that you validate the debt. I dispute the debt and ask that you validate it. Because I guess that's, they were supposed to dispute it. That's the other thing. And then they need to send you the amount of the debt, the name of the creditor, to whom the debt is owed, the statement that unless the consumer, and that's somebody who either has a debt or is assumed to have a debt, a statement that unless within 30 days after receipt of the notice disputes the validity of the debt, any portion thereof, the debt will be assumed to be valid. Well, how do you get around that? Well, you just tell them right off the bat that that you're challenging the debt. A statement that if the consumer notifies the debt collector in writing within 30-day period that the debt or other portion thereof is disputed, the debt collector will obtain verification of the debt or copy of the judgment against the consumer. Well, do it at the beginning. I dispute the claim. Please verify the debt or provide me a copy of the judgment against me that says I got to pay it. Disputed debts. If the customer notifies the debt collector in writing within 30 days, described in Section A, that the debt or any portion thereof is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall cease collections of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or any copy of a judgment. That's all they got to do. If they can't do that, well, then it's not fair debt collection practices. It's under the FTC. The FTC is the only one that has jurisdiction under the under this act. I don't remember exactly what it said. I mean, it may be even a little bit broader than that. It said only the FTC brings cases under the FTC Act. That's where we're taking ours to. So, okay, hey, that's it, guys. They volunteered, right, to be governed by administrative law. So make them be. And if you can, please do donate, either by PayPal or snail mail. I appreciate it. Y'all have a great day. Enjoy your Sunday.